think there's something conceptually strange about going from being tried in an improper venue to being fully acquitted. And so can I just go back to Justice Kagan's point, which is if we assume that the point of venue, or at least a point of venue, was to ensure that the community in which this crime occurred had some say in how these facts were tried, then why would it be that the only permissible remedy for having tried a person in the wrong venue would be to acquit them entirely and not let the community that is the right venue exercise that prerogative?
But I think that's a natural consequence of how it's always been. But
I mean, if we assume that at least part, is to make sure that the people who were victimized by the crime are participating in the trial, it seems to me that your remedy robs them in some sense of the ability to speak to the crime and the issue, because you say the person who may have done this can't be retried if he's tried in the wrong place. So what do we do about that?
The law has always sort of has sort of balanced that and basically said that the defendant's right to venue is more significant. That's a natural.
And the community's right to participate in the trial.
Because that's what would happen. I mean, you would at the common law and at the founding, if the government initiates the prosecution in the wrong venue, takes it to the jury, and there's an acquittal, that's the end. If there's an acquittal on the government doesn't then go and get to say, well, now the next community gets to
But
try.
Isn't that the balancing scenario? If he's acquitted in the wrong venue, then we say his right to not be tried takes precedent. But if he's convicted in the wrong venue, I guess I wonder why that means that the jury that actually has the greatest stake in this situation doesn't get the opportunity.
Because under this court's precedent, he has been acquitted. A jury acquittal.
All right, so let me talk to you about that, because that's another part that I'm struggling with. You admit that venue doesn't have to be submitted to a jury. I mean, even when you raise it, is it the kind of thing that has to go to the jury or not?
It basically is. I mean, the circuit's
No, not basically. I'm saying, okay, we're at trial, pre-trial, and the defendant raises a venue objection. Is that something that the judge can resolve, or must it be submitted to the jury?
It basically must be submitted to the jury. The circuits are a little divided on how much a defendant has to do to put it in issue, but everyone agrees that once it's put in issue, and the threshold is low.
Okay, but I thought you said earlier that we had a scenario in which a judge could be ruling on this as a matter of Rule 29, where the judge could be deciding. All right, so
on sufficiency grounds. Yes.
All right, so let's say it was put to the jury, and then there's a Rule 29, and the judge resolves it. In that situation, if the judge says no venue, is it your position that the government can't appeal? That's tantamount to an acquittal verdict?
Yeah. If the government said, if the judge rules that there's a Rule 29 motion for judgment of acquittal on venue grounds, absolutely. That's basically evidence.
It's not going to. I'm saying, do we have cases to say that, or you're just making this analogy? I guess I'm wondering, would I ever find
it's
an
a natural
appellate?
consequence of our rule.
It's a natural consequence of your rule, but I'm asking you about the law exactly in the following sense. Would an appellate court ever be called upon to decide whether the judge was correct on a J&OV Rule 29 motion in the defendant's favor on venue grounds?
They shouldn't be. I mean, the circuits are divided on.
So if I find those cases, you lose?
No, the circuits currently are divided. I mean, there's lots of circuits that have a retrial rule on appeal, just like the 11th Circuit. And so I'm sure there'll be lots of examples where judges in those circuits do exactly that, and the result is that it doesn't, qualify as an acquittal in the same way.
No, but I guess why doesn't that undermine your argument? I mean, if it is an acquittal, then it seems to me that there shouldn't be an appellate right for the government to go and ask for a review of the judge's determination that there's no venue on a post-trial motion. So if we find those, then it would seem as though the law does not treat the venue question as tantamount to a judgment.
I think those cases would be wrong, just like the circuits that disagree with us would be wrong.
So in ruling in your favor, we'd have to also rule about that, I guess. The implication would be.
Yeah, I mean, I think basically as this court said in Bucks and reaffirmed in Evans, a jury acquittal, a judge acquittal under Rule 29, and an appellate reversal of a Rule 29 motion for insufficiency. Those are all insufficiency determinations, and it's a purely arbitrary distinction to say that, because the jury made a mistake, the government now suddenly gets to re-prosecute. That it's not fair to say that that is what it all turns on, and that's this court's holding in Bucks. And the government, in this case, at JA 113, 114, said to the jury, acquit. If you find we didn't bear our burden of proof here, you should acquit. They agree that bars re-prosecution, and they're saying there should be exactly the arbitrary distinction that this court rejected in Bucks for venue, and there's no basis for thinking venue should be treated differently, because venue has never been treated differently historically at the common law. It's always had
except insofar as our law might allow the government to raise venue questions on appeal if ruled on by a judge.
I don't think I understand.
In other words, you say venue has never been treated differently, but I've identified a situation in which it has, perhaps. I don't know because I haven't researched it. That's why I'm asking you. It would be treated differently, or it has been treated differently, if the government could actually bring an appeal on a judicial determination of venue and have that addressed, because motions of acquittal or judgments of acquittal would not be appealable.
I haven't seen a case like that. I don't know if they exist, Your Honor, but if they do, I would think that they're just basically another instance of the rule that we're challenging in this case that the Court of Appeals have, and that rule is itself the thing which violates Bucks.
Thank you.